This hearing begins with Kevin Lee Tran facing multiple felony charges. He acknowledges his actions and signs agreements acknowledging his understanding of the consequences. In Texas, pledging guilty or true is only the start. The court ensures accountability and competency first.
Okay. Are you Kevin Lee Tran?
Yes, yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran, in clause number 25, DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25, DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
Is it you're either guilty or not guilty? And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. Should have thrown it in first.
In what case?
All of these cases, Your Honor.
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. Hold on. Thank you, Mr. Nicholas.
Yes, Your Honor. I should have done it at the onset. Sorry.
Sorry, they're not in together. Okay, here we go. It's okay. I know. I just have to say it out loud. All right. I'm going to take judicial notice also in all of the court's files. And hold on a second. Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the defense, Judge.
Not from the state, Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. Okay. So now I got to go, where was I? All right. So I went through clause number 0423 and 0424. And so Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand, if I follow the agreements that you've made with the district attorney, that you're waiving your right to appeal?
Yes, Your Honor.
State tenders number 1 in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25 DCCR 0423 find you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0424 find sufficient evidence to find you guilty, and at this time finds you guilty of assault on EMS personnel, sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count 1 is one of the offenses we just pled to. Count 2 is one that's being dismissed. We could just do count 1 of these. That's all right with the court.
1 and 3?
Yes, Your Honor.
Just a second. And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
These cases each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes. Yes.
And did you plead true to those counts because those counts are actually true?
Yes.
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes.
And
Yes,
do you
ma'am.
fully understand them?
Yes, Your Honor.
And again, you understand if I follow these agreements that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Good morning. Are you Christian Lozo?
See.
And for the record, Ms. Burge has already been sworn in and is going to translate for us, correct, ma'am?
Yes, Judge.
Thank you. Mr. Lozo, in cause number 25, DCCR 1423, was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a cap of 15 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Have you both had an opportunity to review that report?
I have, Judge.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense.
Not from the state, Your Honor.
Well, Judge, there is one issue that was brought to my attention this morning by Mr. Lozo in regards to his criminal history. I think there is a notation there from the federal issue, and according to the report we have that he pled guilty and was sentenced time served. According to Mr. Lozo, he was granted asylum during that time. And
Christian Lozo faces a 15-year cap for an aggravated robbery targeting a business owner. The victim was terrorized and injured, with losses including cash and irreplaceable items. The court considers cooperation, remorse, and the premeditation of the offense in final sentencing.
and wasn't actually sentenced in that matter.
Is there currently an ICE hold? Can you check, please? Is there, but Mr. Lozo is not here legally, correct?
No.
Okay.
Yes.
Okay.
Sí, and the first young, first young and us. Una ultimate
Okay.
okay.
All right, Mr. Lewis, you may proceed with argument.
Well, Judge, Mr. Lonzo, he's been pretty straightforward from the beginning of this case of his involvement. He's taken full responsibility, trying to be as cooperative as possible in this matter so the proper parties and everyone can be made whole, especially dealing with the victim and what they lost out on, even to the point where he didn't know the victim would be here, but he did prepare a letter of apology that at some point he would hope been able to read or you let them know of. He does understand he does have other holes from different counties that has to be addressed as well. So at this time, he's really just asking the court for as much leniency or mercy as possible as far as going forward to resolve this matter.
Thank you, Mr. Nichols.
Your Honor, I took into account his cooperation and willingness to accept responsibility when I capped it at 15. This is a pretty horrific robbery where they targeted this woman who's sitting right over here. He knocked her to the ground while holding a gun. They stole $80,000 in cash from her business. They've been targeting this woman. They've been following her and planning this for months, Judge. And I know another individual was involved. That case is pending. Mr. Lozo did essentially debrief as to how they got there and what they were doing. And that was taken into consideration when the cap offer was made. But the facts of this case, Judge, I think 15 is more than appropriate. She was terrorized. She was brutalized. She was injured and had to go through this. She lost items that can't be replaced, some belonging to her late husband they stole from her. They stole her passport along with this huge amount of cash that was from her business. It was obvious they had targeted and sought her out and followed her, and that this was not just some random occurrence, that it wasn't just a crime of opportunity. They came in from Houston to do this, and they've been planning it for some time, Judge. So I asked the court to assess the full 15.
Anything else?
That's on the defense, Judge.
Mr. Lozo, I appreciate your attorney's arguments, asking me for leniency, but any leniency that you, I don't even know if deserve is the right word, but are getting was because of the agreement that your attorney reached with the district attorney for that cap of 15 years. What you two did to Ms. Ordaz is absolutely something, it's out of a movie, scary, for a person who is just living their life, trying to run a business. And in my opinion, 15 is really probably not enough, but I understand, and I think she probably feels the same way. I appreciate, and I'm sure everybody, including her, appreciates you taking responsibility so that there wasn't a drawn out trial, so that everybody involved is going to also have their day in court. And so based on all of that, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery, sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows that this was an agreement I followed, and so you have given up any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and you need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. And if you guys will have a seat at council table, we will go off the record for a victim impact statement. Okay, so this is 24 DCCR 2330, just trying to get up to speed. Good morning, ma'am. And Ms. Miles was in court and entered pleas of true to counts 1 through 4 in a motion to revoke unadjudicated probation. On probation for tampering or fabricating with physical evidence, third-degree felony, and I reset the case.
She pled true to counts 1 through 4, not
Right.
true to count 5.
Not true to count 5, which is the count with regard to that she was so all of these have to do with, most of them have to do with the ISF and the fact that she didn't successfully complete it and was removed from it. And count 5 specifically made the allegation that she was walking around in the quote living room of the dormitory during count time, which was against the rules. We reset it, and I asked for and received the a report, the discharge report from ISF. And so I guess where are we now?
So one of my main concerns is, and I'm not, well, obviously she's just started probation, but there is a history of mental health issues. I don't know if necessarily if Ms. Miles has been on the mental health caseload. There have been several diagnoses that she has. I'm not sure if proper medication may be an issue. I know she recently told me that they have put her back on some type of medication, which I do think has contributed to some of the behaviors. Due to her not being on probation very long and not being at ISF very long, we are asking that she be given another chance to try to make this right to successfully complete the probation. Mainly that was the issue on the motion, was her not completing ISF and adhering to all of the rules and regulations there. So I don't want the court to totally give up on her at this point, but we understand obviously that a person needs to successfully complete ISF when they are ordered.
I mean, what option? And just for the record, if you'll raise your right hand, please, ma'am, do you swear or affirm the testimony you're given this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so what options and what's probation's thought with
The court finalizes sentences with competency confirmation, plea validation, and firearm restrictions. Both defendants face the consequences of their actions, and the justice system ensures victims' rights are recognized.